As Magdalena kindly said, I work as a legal officer with UNHCR, the representation to the EU in Brussels. And in that function, I do mainly two things. One is working on the CS reform, and they're mainly on the Qualification Regulation, on the Asylum Procedures Regulation. And I also work on UNHCR's interventions before the CJEU and the European Court of Human Rights. I have not quite 45 minutes anymore, but what I plan to do is the following. I'll give you a quick introduction, then I'll run you through the proposal of the Qualification Regulation. After that, I'll discuss where the file is at now, because of course the proposal is already quite not old, but it's from July 2016. And then I'll finish up with CJEU jurisprudence on qualification and end with some conclusions. As for the conclusions, I'm actually very thankful to the previous speaker who concluded his presentation with the question or with the statement that what is being harmonized are restrictions. So as I run you through the qualification regulation, you can make up your own mind on whether this is the same case. Also, as I go through my presentation, I really encourage you to think critically about the issues I'll present, to think about your own practice and how the issues that I'll present might affect your own practice. And that is, of course, for the representatives from the judiciary here, for the legal practitioners, also for academia. And I should also say that much of what I'll say is based on the UNHCR comments on the proposal for the Qualification Regulation, which you have in your pack already. So if you're interested, feel free to read the details. And as I have around 45, let's say 40 minutes, and then we'll have some time to discuss. If that gets too long, you have a coffee break afterwards, and I'm sure a very entertaining presentation by Flip Schüler that you can already look forward to. But for now, qualification. So a bit of background to the proposal. As you know, qualification has been covered by a piece of European law already for quite some time. We had actually 14 years. We had the first qualification directive in 2004, and then the recast of the qualification directive in 2011. But in many ways, these two instruments did not live up to what many people expected they could achieve, and I want to make three background points here. I looked up the protection rates, so some statistics, and it's clear that despite already existing common criteria, we have vastly different protection rates in Europe. To give you just one example, the protection rate of Afghans in 2017 was close to 100% in some member states. For example, 97% in Luxembourg, 92% in Italy, but then close to zero in other member states. So that was 1% in Bulgaria, 6% in Croatia. And we see similar disparities for other major nationalities, for example, Iraqis. Second point by way of background, there is also no consistency which of the protection statuses a person is granted. So Syrians, for example, in general, in 2017, enjoyed quite high protection rates, but it was very unpredictable which one they would get. So, for example, in Italy and Greece, Syrians were granted 83 or even 91% refugee status and only 0 or 2% subsidiary protection. In Spain, it was the opposite. There, only 1% got refugee protection and 95% of Syrians got subsidiary protection. And third, last point by way of background, so not only the chances of getting protection in the first place were very different in the various member states, but also the level of rights that beneficiaries got once they got the respective protection status. So you probably know that in terms of residence permits, social assistance, freedom of movement, there are quite different standards throughout Europe, and that all despite the fact that we already have a piece of European legislation on qualification for quite a long time. So all of that does not sound very much like a common European asylum system, and that was really the background against which the Commission drafted the recast, or actually the now proposed regulation to regulate qualification. The consequence of this situation is obviously onward movement. So we saw both asylum seekers and beneficiaries going to countries where they expected the best chances and the best treatment. And that in turn contributed to a very uneven distribution. And that again led to political support dwindling, because only several member states, a small number of member states, were seen to shoulder responsibility for the majority of people. So that background explains really the main goals of the regulation, some of which we have already heard today: harmonization of the criteria, more convergence, meaning more convergence on recognition rates, and then a third that we hadn't heard before, to render status non-permanent, so to provide protection only for as long as it is needed. Preventing onward movement is, of course, a goal that runs through the whole reform, and then harmonization of the rights once person have received protection. Importantly also, and unlike what we just heard about the Reception Conditions Directive, this is proposed to be a regulation, which means direct applicability and prevalence over national law, which in itself is supposed to contribute to harmonization. But that also explains why negotiations on this are so difficult, because member states really fear they lose control over the file. And lastly, of course, all of what I'm going to say today is not yet law. So we'll see what will be the outcome. We know what the Commission proposed. We know what the Parliament thought about it. We, to a certain extent, know what the Council thought about it, but it's not yet through. So let's see what the Commission has proposed. So what's new? One of the really main points that got probably was among the issues that received most attention was the introduction of a mandatory status review. So as I just said, the regulation seeks to make protection status non-permanent. And the measure to do that is to introduce a mandatory, regular, and systematic review of whether protection is still needed. And that is supposed to be done, in particular, on 2 occasions. And that is when there is a significant change in the country of origin, which is relevant for protection needs, and then on the occasion of residence permit renewal. Residence permits are to be renewed for beneficiaries of subsidiary protection after 1 year, and for refugees after 3 years. So on that occasion, the proposal proposes to do a review of status. So that's one. Second, checks on whether an applicant could not be reasonably expected to go to another region in his country of origin where he's not persecuted. So internal protection alternative checks. Perhaps the most common practical example would be Afghanistan. So as a whole, the country might not be considered safe, but there are several European countries today that think Kabul at least is safe, at least for young, healthy males. And the qualification regulation introduces safeguards to that concept. So we know that concept already from the QD, but there are changes to it. And the most significant is that it becomes mandatory. And there are several safeguards. So for example, what is new, that the asylum authority who bears the burden of proof to prove the accessibility, effectiveness, and durability of the protection available in the part of the country. And also, as has been mentioned in other files, there is now the obligation to take into account the country of origin information provided by the European Asylum Agency, the future to be established EUAA. Next, the proposal seeks to prevent onward movement of beneficiaries also, and it does so by amending the long-term residence directive. And the way it does so is to restart the clock every time a person moves irregularly to another member state. And then the time frame, the 5 years time frame to be eligible for long-term residence status starts anew. So every time the person moves, the 5 years start again. Another new thing is the mandatory rejection of certain surplus claims. So you know, surplus claims are claims that arise, protection claims that arise once the person is already in the country of refuge. And the proposal introduces a provision according to which if the refugee has created, self-created, the circumstances for such persecution claims to arise, then the application shall normally not be granted. That's a bit of a strange formulation, but it essentially means, for example, if you have a person who always, let's say, concealed his political activism in the country of origin because he would have been or she would have been persecuted for that, but then in the country of refuge finally is able to express his or her political views, his dissident views, and thereby creates the persecution claim, that might be covered by such a situation. However, you should note that this proposal, this Commission proposal, was limited to subsequent applications. So in those cases, the rationale seems to have been that if a person has already received a final rejection on the merits, then in a subsequent application, if there are these self-created situations, they are somewhat disingenuous. So that seems to be the rationale for the amendment. And by the way, I'm going to give you the UNHCR perspective on all of what I'm saying in a bit. I just want to give you the broad overview first. One important thing is also there are still differences between the two statuses, between refugee status and subsidiary protection status, while the previous recast, so the 2013 recast, really set out to bridge the gaps in terms of rights that those two statuses get. We still see such a non-harmonization on some quite important points. I mentioned already status review takes place more frequently for subsidiary protection beneficiaries, and also social benefits can be reduced to core benefits for subsidiary protection beneficiaries. And then lastly, also the threshold for exclusion is lower for beneficiaries of subsidiary protection. However, new provisions in the proposal also introduce equal treatment rights. So for example, when it comes to employment-related rights, working conditions, right to assembly and things like that, and also validation of prior experiences. Two last things, or three last things. Integration. There are two new points on integration. First, integration measures may be made compulsory, and to give that teeth, these integration, effective participation in integration, social assistance can be made dependent on such an effective participation in integration measures. In some member states, this has already been interpreted. Austria, my state, for example, has already been interpreted as you need to speak a certain level of German before you're eligible to social assistance. And then that's the last slide on new things. The definition of family members has been extended to also include family members that are formed, or families that are formed in transit. So that is supposed to reflect the reality of today's flight movements, where many people stay en route for many months or years, and obviously form relationships. And these newly formed post-flight relationships are now also covered by the definition on family members. And then the last, or the two next points, are reflections of CJEU case law. There is now an obligation to respect the rights to human dignity and the respect for family life in credibility assessments, and subsidiary protection now incorporates the sliding scale principle of El Ghafaji, which I'll also mention in a bit. Yes, that's basically it. UNHCR's positions, which I mentioned you all find in your folder if you want to read all the details. In general, all these case law related updates that I just mentioned are welcome in our view, in particular the extension of family members, that there is no need to prove the to be specifically targeted, to be eligible for subsidiary protection, and also the new rule, so that's the ABC judgment, that you do not have to be, or an applicant cannot be expected to conceal something that is so inherent to his or her personal identity. In this case, it was the fact that the applicant was homosexual. The same is true for religious persecution claims. So that is now also in the proposal. In addition, the newly introduced guarantees for applying the internal protection alternative are welcome from our point of view. The equal treatment rights that are introduced equally so. One of our real main concerns was on status review. So if that provision would go through, and I say already it won't, at least not in its original form, this would mean that protection becomes explicitly temporal, and it would mean a big impact on the person's integration prospects, because if you know, and if your employer knows, that your residence permit is valid for 1 year and then it comes to re-evaluation, then you might have a hard time either getting a job or finding your way in this new society. But also for member states, it's a huge administrative burden. And that is also what most member states seem to have realized in the negotiations, and that's why in the final deal now it's there, but it's let's say it has no teeth anymore. On status review, another point would also be that Europe, the person who come to Europe often flee conflicts that are of a protracted nature. So even if you do this whole exercise again after a year to re-evaluate the status of a person, it's not very likely that the underlying conflict will have disappeared. And also you would need to give a change of the country of origin situation time to consolidate before you could actually do cessation. And then cessation brings me also to the point that you can already do it. So under the QD, you already have the option to do cessation if you really have a change of in the country of origin. So this new mandatory systematic nature of reviewing status is just not needed. So that is also why we had recommended to delete this provision. On checks of internal protection alternative, we had recommended this stays optional, first for the reason that IPA is not a standalone or independent test within refugee status determination, and because we were concerned about delays, because in every case where IPA is applied, the authority of course needs to do an in-depth analysis, and with these new safeguards even more so. So in order to prevent delays, we recommended that this should stay optional. Sur place claims, the provision I explained earlier of the person who is politically active but only, or is homosexual but only comes out in the country of refuge and then has his or her claim rejected because he or she created the reasons for persecution in the home country. That was of major concern to us. We were of the view that it is irrelevant why the person is at risk of persecution. If that is the case, then in order to live up to the obligation of non-refoulement and Article 3 of the ECHR, the person cannot be returned. So it's immaterial. What counts is that the elements of the refugee definition are there, and if they are, then that's enough. You don't need to look into why the reasons, why the situation arose. And so again, we recommended to delete this provision. Next, differentiation between protection statuses, as was the goal, or one of the big goals of the 2013 recast, to harmonize those two statuses. We had welcomed that very much at that time, because we're of the view that in most cases such a differentiation is not justified, because people mostly have the same flight experience, have even the same protection needs. As you've seen at the very outset, the statistics that I presented, it's to some extent arbitrary which one you get. It depends a lot on which country you find yourself in. So we recommended in these proposals to harmonize those statuses fully, and to wherever you have these differentiations still, to align these provisions. Integration, linking success in integration to social assistance, again, was of a big concern to us. UNHCR, integration in our view is a two-way process, and before we can even talk about integration being compulsory or even making social benefits hinge on successful integration, such integration measures must be available. They must be there, they must be accessible, they must be affordable or free of charge, before we can even start talking about whether they should become compulsory or not. So again, this provision should be clarified to this effect, which in fact has happened on the Parliament's initiative. And then lastly, before I come to what happened after the file was issued, on sanctions for onward movement, UNHCR is actually of the view that a person who is self-reliant should be able to freely establish him or herself in any member state after 6 months and not after these 5 years, and therefore also these sanctions should be taken out. I would now come to kind of more the political process, unless there are any questions so far on what I presented on the issue. So I would now go into what has happened. Okay, then maybe save your questions for the end. So where is the file at now? The Commission proposal came out in July 2016. The EP formed its position about a year later. Council also quite quickly. We were, with the EP position, we're quite happy. So it incorporated very similar changes as UNHCR had suggested. For example, as I said, status review was kind of, the teeth were taken out, so it's only a may clause, and it's also no longer on the occasion of residence permit renewal. So that's very good in our view. As for the Council position, without surprise or unsurprisingly, the Council wanted much more flexibility. The Council was very concerned with all of these shall clauses and with the instrument being a regulation in the first place, and they wanted to have more flexibility. We also heard on other proposals they were concerned on administrative burden, on changing their systems, on all these mandatory provision, on the EUEA now giving them the country of origin information, which are also shall clauses. So essentially they were concerned about losing control or having to change their national systems. And that's why in the Council position you find numerous, or it's really scattered with may clauses. So many of the shall clauses had been replaced by may clauses. In particular, the Council really wanted to keep the length of residence permits flexible, so really at the member state's discretion of how long they want to issue the residence permits for. And one thing that was very concerning for us, the Council had proposed to delete references to the Court of Justice of the European Union judgments, which was not very clear why, but I mean, on the positive side, the Council, for example, extended the list of vulnerable applicants, although we heard today that it might not always be so great to have a very, very long list, because it then might be taken as an exhaustive one. Okay, but the next step were trilogues. In trilogues, which started in September 2017, because all of these concerns that I just mentioned, progress was initially rather slow. Some actors, the Parliament mostly, wanted to wait for also some judgments to be out first, which, for example, one of them concerned the aging out of minors during the asylum procedure. That judgment is by now here. And then others also insisted, as we have heard a lot of times today, on the package approach. So nothing is agreed until everything is agreed. We're not moving on QR before you move on Dublin. Despite all these problems, the Parliament and the Council were able to reach a provisional agreement in June 2018. And I can just give you the very broad overview points. I think the Parliament perceives this as something in which they had quite a lot of success, so it seems they're more or less satisfied with the provisional deal. The status review, one of our main concerns in that provisional agreement, is not mandatory, so it's optional for member states. Residence permits equally, member states have the option to grant longer, but there's a general timeline of 3 years validity period for refugees and 1 year for beneficiaries of subsidiary protection, so sticking with what the Commission had originally proposed. Family unity also now includes not only in this provisional deal, so we still don't know what's gonna be the final result, but family unity not only included post-flight spouses, but also dependent adult children, so children not married but already adults. What else? The obligation to participate in integration measures was there. However, as I said earlier, the realization that before you can make anything compulsory, it must be there, it must be accessible and free of charge, that has been also incorporated. And then lastly, the possibility to reduce benefits for beneficiaries of subsidiary protection to core benefits is also there, unqualified. But as we already know, so as I said, Parliament, I think, was quite happy with it, but the deal was not accepted by the ambassadors in Coreper on 19th of June. Therefore, essentially, QR failed. There were rumors about France and Germany not being very happy with national security issues, and also on the interplay of national systems with the new EU statuses being regulated by regulation. And also some, reportedly, some Southern European member states wanted to keep the package approach because they felt that gives them a greater leverage in other files. And overall, some counterparts reported that member states felt, well, SEAS reform is stalling anyways, so now we can say everything that we oppose in that reform. There's no common spirit to move towards the end because it's not gonna be finished anyways. So that's a bit the situation where we're now. The Austrian presidency then took over, held bilaterals, but as we've heard, their focus is really more about border controls and externalization proposals, so SEAS doesn't seem very high on their agenda. And despite the fact that the European Council is asking for updates and the Parliament even more so, it seems they might be more ready to invest their energy elsewhere. We know also that in January the Romanians will take over, and it seems as first-timers for them, because they have never been the presidency, they might be willing to do more on SEAS reform. In fact, some actors already approached them and asked them to please revive SEAS when they take over to fix what the Austrians did. But we know we're running out of time. We have EP elections in May, and we know that even if the Romanians really want to push SEAS, they will have very, very little time to do so. I'm almost done. The very last thing I want to do, but really briefly, because we have about 4 minutes left and I really want to hear your take on all of that. While politics sort itself out, what I hope is that you will continue, those among you who are practitioners, to bring cases to the European Court of Human Rights, because at least in our view, these should be the fixed parameters of anything that is done under the legislative wing of things. And the few judgments I wanted to mention, one I had mentioned, so Al-Ghafaji, that's the 15C serious harm provision that is now in the proposal. Credibility issues, so we had the YZ judgment of 2012, which is about concealment of religious belief in order not to be persecuted, and the CJEU said no, if a person has a risk of persecution due to his or her religious beliefs, if returned to the country of origin, then the person must be granted protection status, and the person cannot be expected to conceal that religious belief. And something very similar was then said a year later in XYZ, but this time concerning sexual orientation. And then we had 2 more cases on sexual orientation testing, if you want. So one was about testing based on stereotyped notions. So the CJEU basically said you cannot test whether a person is homosexual and therefore has a persecution claim in his or her country. You cannot ask for evidence that proves that orientation, and if that evidence, for example, films or even performance of sexual acts before you is being offered, you can take that. And also, there is no lack of credibility if the person has not brought up this claim at the very first occasion that he or she got. And then a follow-up case just earlier this year, referred by a Hungarian court, which asked whether it's okay to get a psychologist to test the sexual orientation of the applicant by doing prospective personality tests. So that was kind of these ink dots, if I'm not mistaken. And the court said no. So you cannot you cannot get a psychologist as an expert to do these psychological personality tests in order to determine whether the person is homosexual or not. I want to finish with 3 cases on exclusion, which going through the cases on qualification by the CJEU seem to have been the largest number of cases. We have the very classical lead case of BND, which was referred by a German court. It's a case from 2010, and it's essentially the holding is you cannot automatically apply exclusion to a person just on the basis that he or she is listed on an anti-terror list. What you need to do in each and every case is an individual assessment, a really deep down assessment of the specific facts and to establish what the individual had done, and you cannot apply, so exclusion can just not take place if you skip this analysis. Similar a similar case that was based on the BND judgment was in just last year, Lunani, I think also a case from Germany, if I'm not mistaken. Belgium, thank you. Where the court said very similar things. So you can apply exclusion even to a person who did not him or herself commit terrorist acts, but only supported them by doing recruitment, organization, financing, and so on. But you, again, always need to do this individual assessment of the specific facts. You always need to establish the individual role of that person. And the very last case I'm going to mention is Ahmed, which was just decided a month ago, a case referred by a Hungarian court, where the question is, what is the threshold for excluding beneficiaries of subsidiary protection? So the threshold in the recast directive and also now in the regulation proposal is serious crime. And in Hungary, the serious crime was defined as any penalty that is at least 5 years. And then the question was, can just the abstract penalty, no matter what in fact was being applied for the person who was subject to these criminal proceedings, is this 5 years abstract penalty enough to trigger serious crime, to trigger exclusion based on serious crime or not? And again, the court said no, such an abstract application, automatic application is not enough. You need to assess the seriousness of the crime as it actually happened. So you need to assess what actually happened. You have to do an investigation into all the circumstances of the individual case. So I think in sum, it's clear that the CJEU is our friend when it comes to procedures, and that it really requires that in-depth analysis. You find other cases related to qualification in the material that was handed out to you, but I'm finishing up with a few concluding points. On the general regulation, and as it has changed over the 2 years it's been negotiated, we see many provisions that have been rendered very ambiguous. We see a regulation that is full of may clauses, which of course defeats a little bit the purpose. And we see very concerning developments as I ran you through. So it's clear that harmonization cannot only be achieved by choosing a regulation over a directive, but what is needed obviously is political will. And we see today discussions in Brussels really focusing on externalization, on regional disembarkation proposals, on closed centers, on border management broadly. So I'm afraid the outlook is not too rosy for the completion of the SEAS reform. And as I mentioned, if we're realistic, the time is running out because EP elections are coming up. However, the QR is actually one of the proposals which are most advanced, so we'll see. And from our perspective, there is definitely a need for greater harmonization. However, that should not happen at the cost of harmonizing at the lowest common denominator. So maybe as we go through these negotiations, it would be good to keep in mind that perhaps the three most important parameters are: we need a system that ensures fair and non-discriminatory treatment of asylum seekers and beneficiaries. We need a system that is manageable by member states and does not feed into these current discussions of, oh God, we're losing control, we're no longer in control of our system, the EU takes it away from us. So we need to buy in and support from them. And in our view, full respect for the law, and thereby also taking the advice that Strasbourg and Luxembourg are offering is crucial, because otherwise the whole legitimacy of the proposal is undermined. And again, we would feed into narratives across Europe that threaten the rule of law and the legitimacy of judicial institutions. So maybe to keep these three parameters in mind. I ran a tiny bit over time, but I started a bit late, so I hope we still have enough time for your questions. So please, if you have any, I'd be glad to take them. Thank you.